Hi, I'm Barry Taylor from Equip for Equality. Adults with disabilities, including older adults who have physical, cognitive, sensory, or mental impairments, have the right to make their own decisions, including about health care, how to spend their money, where to live, and personal relationships. In Illinois, an adult is anyone 18 years or older. This video will provide you with information about adult guardianship and how to protect your right to make your own decisions. If a judge decides in court that you're unable to make good decisions for yourself, the judge may appoint a guardian to make important decisions for you. Now, just because you have a disability or a medical condition does not mean you need a guardian. A guardian takes on the legal responsibility to manage those areas of your life that the judge has decided you're unable to manage yourself. A guardian can be appointed to make personal decisions for you, called guardianship of the person, or make financial decisions for you, called guardian of the state, or make both financial and personal decisions, called plenary guardian. Once a guardian is appointed by a judge, it can be difficult to get the judge to end the guardianship. So it's important to know how to avoid a guardianship or remove an existing guardianship if you feel you do not need one. It can be hard to know if someone's your guardian. Sometimes people, like parents, think they're the guardians of their family member, but they may not be. Once you reach age 18, parents do not become your guardian unless they have been appointed by a judge. When a guardian is appointed by the judge, the guardian is given letters of office, a paper that shows that he or she was appointed by a judge to make decisions for you. We at Equip for Equality can help you find out if someone has been appointed guardian for you, if you need help figuring this out. The law requires that you be informed in writing at least 14 days in advance if there's going to be a hearing in court to decide if you'll need to have a guardian. If you receive a notice of a court hearing to determine whether a guardian should be appointed for you, contact a lawyer right away so that you can get information to understand all of your legal options. The purpose of the hearing is to allow both sides to present information so that the judge can decide if you do or do not need someone to help you make some or all of your decisions. So it's very important to attend the hearing and to prepare for it by contacting a lawyer as soon as you receive the hearing notice. You should also assist the lawyer in arranging for people who know you and know about your abilities to come to the hearing and testify on your behalf. Now, what are your rights at the hearing? Well, you have the right to be present at the hearing. You also have the right to be represented by a lawyer and the right to ask for a jury to hear your case. You have the right to present evidence and to confront and cross-examine witnesses. You have the right to ask the judge to appoint an independent expert to examine you and give you an opinion about your need for a guardian. You have the right to ask that the court hearing be closed to the public. You also have the right to tell the court that you do not want a guardian. And you have the right to tell the court who you would prefer to have as your guardian if the judge decides that a guardian needs to be appointed. There are several different kinds of guardianship in Illinois. First, a temporary guardianship may be appointed by a judge without the parties present for emergency reasons. A temporary guardian acts as guardian for a maximum of 60 days. There's also a limited guardian, which may be appointed when a judge decides you're unable to make your decisions in some, but not all, areas of your life. In that case, the guardian's authority would be limited to only certain kinds of decisions, such as medical decisions. A plenary guardian is appointed when a judge decides, after a hearing, that you're completely unable to make your own decisions. A plenary guardian has full decision-making authority over your personal and financial decisions. If you have a guardian, the law says the guardian must follow your wishes as much as possible and support your independence and self-reliance. But remember, there are other legal and non-legal tools that can help people with disabilities manage their affairs in ways that are less intrusive and often more effective than a guardianship, such as a power of attorney to make your financial or medical decisions, representative payees to help you manage your benefits. If you want more information about the rights of people with disabilities and guardianship, you can contact the Illinois Guardianship and Advocacy Commission at 866-274-8023 or contact Equip for Equality at 800-537-2632 or at equipforequality.org. Thank you.